Honorable the Chief Justice of India, Honorable the former Chief Justice of India, Pujya Shri Matoshri, distinguished guests and invitees, respected ladies and gentlemen, a very good evening to one and all. Maharashtra, and by extension, Nagpur, has a very special place in my heart. Anyone aware of the trajectory of my judicial career would notice the inextricable link with Marathi Manush that has enabled me to occupy high constitutional offices. To begin with, in 2005, I was recommended for elevation as a judge of the Calcutta High Court by the then Chief Justice, Justice V.S. Sirpurkar, who is present here. He hails from Chandrapur and was a regular practitioner in Nagpur. And this is what he shared to me. Perhaps till now, Justice Sirpurkar has the rare distinction of presiding over benches of all the three chartered high courts. No other judge has had that opportunity. I was then recommended for appointment as the Chief Justice of the Bombay High Court. And the Collegium was presided over by another judge from the Nagpur Bar, Chief Justice Sharad Arvind Bobde. Moving ahead, I was recommended for elevation as a judge of the Supreme Court of India by another Chief Justice of India who was born in Solapur, a son of Maharashtra, Chief Justice Uday Lalit. I was thereafter sworn in as a judge of the Supreme Court of India by another Maharashtrian, Chief Justice Chandrachud. Although I was very unfortunate in not being able to serve under Chief Justice Lalit, I am now fortunate to be a part of the team led by Honorable Justice B.R. Gawai. Sir is my captain in the legal field, in the judicial field, and also I would like to have him as a captain on the cricketing field also. Nagpur Bar Association, this is my request to you before November 24, arrange a cricket match between the bench and the bar, and the bench would be led by Justice Gawai. You have heard Hindi and Urdu couplets. Now it is my turn to do the same, but in a different language. And as I said yesterday, I'm not too good at Marathi, but even then I'll try my best. Please pardon me if I am wrong. सत्याच्या शिखरावर हा भूषण उवा, पण त्याला मातृभूमी व मायेची मूल आहे, म्हणूनच तो खरा भूषण ठरला. Over the last few days, we have been attending functions to felicitate Justice Gawai. Today, taking a cue from what Justice Gawai has said in his past addresses, I would like to raise 2 points. In Aurangabad, Chief Justice said and warned everyone about judicial terrorism. Now, it cannot be gainsaid that judicial activism has come to stay as a means of ensuring justice in a dynamic society. Whatever orders we passed in our jurisdiction while hearing public interest litigations is in the nature of activism, to bring order to society when we find that the marginalized, the needy are being deprived. Now, sometimes judicial activism progresses towards judicial adventurism and also borders on judicial overreach, which critics say amounts to judicial terrorism. Now, since this is a concern which has been expressed by the Honorable Chief Justice of India, may I, with His Lordship's permission, address my former colleagues of the Bombay High Court, the present judges who were not there when I was Chief Justice, and all the judicial officers who are present here, to remember about 5 principles. These are all foundational principles, core principles, but can suitably be adapted to Indian conditions, Indian judiciary. It is all about D, S, N, N, and S. What does D stand for? D stands for Dharma. Dharma here is not religion. Dharma is righteousness. Do what is right. S stands for Satya. We as judges, we must pursue the truth, our search for truth, while sifting facts, evaluating the materials on record, while weighing the evidence, while rendering judgments. We must try to reach at Satya. The first N stands for Niti. Niti would mean the principles of law, the constitution, the statutes, the precedents set by the higher courts. Let us not forget to abide by the principles. Otherwise, what the critics say, that the judiciary is guilty of judicial overreach or even judicial terrorism, we will not be in a position to counter them. If we abide by Niti, we will be staying within our bounds, not crossing the Lakshman Rekha of jurisdiction. The second N stands for Nyaya, the quality of justice that we dispense to the persons who are before us, and according to the merits of the case, what the justice of the case demands. And all these to ensure the last S, that is Shanti, peace in society. We are an important stakeholder in society, and we must also strive along with the other organs to ensure that there is no Ashanti because of our decisions. And let me tell you, I have found all these 5 qualities in abundant measure in our Honorable Chief Justice. Everyone has been referring to the recent bulldozer justice judgment. If you analyze the judgment, you will find that all these 5 qualities are there. The second point of concern which the Chief Justice flagged in Aurangabad was that one of the finest Chief Justices of the country then could not be brought to the Supreme Court. And the Honorable Chief Justice lamented that we do not always get what we want. Sir, this is an appeal to you. This is high time that we dispel the misconceived notion that judges appoints judges. Critics of the Collegium system have been vociferous. Why should there be a Collegium system? Let me go back to the 1980s of the last century and recall 3 Chief Justices of Bombay High Court. Chief Justice M.N. Chandurkar, Chief Justice Chitutosh Mukherjee, and Chief Justice P.D. Desai. Those who have practiced before these 3 Chief Justices and others would vouch that they were no less than the judges who made it to the Supreme Court in the 1980s. Does anybody question the pre-collegium system of appointment of judges? We only refer to the supersession of the 3 judges by a judge in 1974, just prior to the Keshavananda Bharati judgment, and then the supersession of Justice Khanna by the next senior Supreme Court judge. But why doesn't anybody question why Chief Justice Chandulkar, Chief Justice Mukherjee and Chief Justice Desai did not make it? Even judges of the Collegium said, some of the judges, that the system is opaque. Now we are trying to bring in transparency. I would say from opacity, the system is now translucent. But sir, under you, we expect that there should be a fair and transparent process. And as you have repeatedly said, there can be no compromise on merit. Sir, we need to tell the society that if judges were to appoint judges, then all the recommendations made by the Supreme Court Collegium would have been acted upon. That does not happen. I recall when I was a member of the Calcutta High Court Collegium in 2019, we had recommended a member of the bar. 6 years have passed. Nothing has been done. He is now 58 or 59. He would not accept judgeship. Why does this happen? Has anybody questioned? So therefore, the external forces which prevent the Collegium's recommendations from being acted upon should be dealt with sternly, and I feel that whatever proceedings are pending should be given top priority to ensure that merit and only merit is considered and not extraneous considerations. I think as the president of the function, I should not exceed the time limit. I thank the Nagpur High Court Bar Association for extending this honor to me. Thank you very much. Jai Maharashtra, Jai Hind.